Yeah, I want actually to ask Carla a few questions to make it more understandable for us. Because you know, as all of you know, the legal language is completely something that is very difficult to understand. So it's good to have someone expert here to explain to us what all these legal terms are. For example, we have the Council of Sharia, we have the Muslim arbitration tribunals, and you know, lots of, and we have arbitration acts, 1996 or something like that, and these are all, you know, somehow relevant, related to each other. And I'd like to ask you, what is the difference between the Sharia councils and the Muslim arbitration tribunals, and also what is the relation with the Arbitration Act 1996?
Right, thank you. That's a very good question. There's been a lot of misinformation in the press. Thank you. There's been a lot of misinformation in the press about the introduction of Muslim arbitration tribunals in this country recently. And people seem to think that, suddenly, somehow, something that the government has done has led to the introduction of these tribunals in this country. That's not the case. The important distinction that has to be made and that everybody needs to take on board is the distinction between mediation and arbitration. Mediation is a system that anybody can use whereby two people get together and they try and agree to resolve a problem. A mediation can't be subject to laws or religious principles of any description. On the other hand, an arbitration is equivalent to a court, except that it's in private. The Arbitration Act 1996 allows parties to private disputes to resolve them in any way that they choose, under any legal system that they choose, as long as they comply with certain requirements. The Arbitration Act 1996 does not apply to either criminal law or family law, and the misconception that seems to have come out of either Rowan Williams' speech or the Lord Chief Justice when he spoke subsequent to the Archbishop of Canterbury's speech is that actually it's open to parties to use the Arbitration Act to resolve private family law disputes, and that's not the case. Even if it were the case, no decision of any arbitration tribunal that's made in this country could be enforced by the court, and the same with any mediation decision, could be enforced by the court if it's not compatible with the principles of UK law or is against public policy. So, for example, if you had a situation where a Muslim arbitration tribunal had made a decision about the custody of a child, say, and it had taken the child away from the mother at the age of 7 and given it to the father, because that was the Sharia principle, that would be against public policy, because public policy always puts the interests of the child first. So there would be a situation where even if it were legal to create these agreements, if you went to a UK court, you wouldn't be able to enforce it. Now, the problem is that a lot of women within Muslim communities don't realise what their legal rights in civil courts are. And from what I can gather from the research that's been done on the ground, many people think that these decisions of Muslim arbitration tribunals are actually binding. If it's the case that the Muslim arbitration tribunal system that's been set up is actually being used to impose legal principles on mediation, that's also wrong, and that also needs to be investigated. So that there's a lot of work still to be done, both in relation to raising awareness on the ground so that people actually know what the distinction between these two systems is.
It's one of the things that many lawyers have raised recently is that it's going to cause a dual kind of legal system, and it's going to cause a lot of trouble, you know, trying to see which one is legal, which one is not, and this is going to cause a lot of legal battle, dual legal problem. Do you think that's the case?
Well, if you look at the big picture, having a dual legal system raises the first question, which is how do you decide who's going to be tried under these different systems of law. Who is a Muslim? Who is a Jew? Who's bound by these different legal systems that could potentially arise? And that's a very important freedom and secular decision, because under a secular legal system, everybody has the same rules applied to them, irrespective of their faith. What we need to make sure is that there is one system of law for all, as the One Law for All campaign is trying to put across, so that nobody will be discriminated against or included in a subgroup of a legal system within this country, because within minority groups that would want to have separate legal systems in this country, it is minorities within those groups, such as women and children, that will suffer as a result of having those systems imposed on them. And just looking at it from a practical point of view, and people are free to agree to resolve disputes in whatever way they want, but they have to be subject to UK law and public policy.
Right, thank you. While we're still on the legal part, shall I ask Yossi to also tell us, they say it's voluntary, everybody can choose to go and not to go, so what's wrong? Why we are not very happy about it? Can't they just choose to go to that system? Is it voluntary or not?
I don't think that it is voluntary, because the problem is that the reality is different to what the law says. It is not voluntary for women to go to these tribunals, because there is lots of pressure on them from the community, from their families, from the dominant husband. I've interviewed a woman recently who didn't know about her rights, because she was only 18 when she got married in Iran, and a year after their marriage, she moved to England with her husband, and after 1 month she wanted to get a divorce. She wanted to separate from her husband, but she said that she didn't know what to do, where to go in this country. Even though she was in an abusive relationship, she didn't know that she had to go to the police, because it's different in other countries to go to the police for matters like this. People don't usually do that. They go to the families, they go to the mother and father to seek advice on what to do. She even went to her friend and asked, what shall I do? And they didn't even know what to do. Finally, she got advice from someone to go to the police, and from there she was passed to the women's refuge. But before that, the only place she knew to go was the Islamic Center in Holborn. And the only thing they did for her was to send someone to take her to a bed and breakfast. And on the way there, the woman was warning her that there is going to be lots of Arabic men in the bed and breakfast, and she might get raped and abused. So you can imagine what you might be thinking at the time. So she just decided to go back home halfway there and return to her abusive husband. The problem is that these women do not know what rights they have, and it's very difficult to get the message across, because as in this case, she used to live in a Muslim community, and she even went to a college where she described that there was no men, and if there was a man in the college, in the library, they would put a note outside the door saying there is a man in the library. So you can imagine it's very difficult for her to find out what rights she has under the English law other than the Islamic law. That's why they don't have a choice. They basically yield into these Sharia courts.
Right, thank you. And I just want to welcome Yasaman Ali Brown to our panel. She just arrived.